will be, as Gaston will be about technological challenges from the international legal perspective. The esteemed guest, will be touching this perspective from different points, from their research points. And yeah, I didn't introduce myself. I'm sorry. I am a professor of law at the University of Warsaw. In Poland, I have also, I say it's a linguistic touch because I have also additionally a PhD in applied linguistics. I work also at the Faculty of Applied Linguistics, and I am head of Department of International Legal Communication, which is in plain words, it's communicating the law, it's talking about law in a comprehensible way. And I would like to stress that all our guests, whom I was privileged to invite and who accepted this invitation, are gathered around this area of international legal communication because we work together. And I will be saying about it in my short speech. We teach in the new International Legal Communication Master Program at the University of Warsaw. So I'm very happy that my colleagues accepted this invitation and they will be holding their speech today. They are with us. So first of all, I would like to welcome and introduce Professor Ryszard Piotrowski. Professor Ryszard Piotrowski works at the Faculty of Applied Linguistics at the University of Warsaw. He is constitutionalist, very famous person in Poland. He is very, very renowned and very regarded commentator of public life in Poland. And I'm very happy that Professor Piotrowski is today with us. Professor Piotrowski will have a speech on new technologies and new human rights. Please, the floor is yours. If I can help with sharing the screen, or if Anya will help.
I understand that I can start.
Yes, please.
My presentation. First of all, let me thank you very much, Professor Siewicz and Professor Gaston Becerra for this unusual and outstanding opportunity and privilege to contribute to the colloquium. My subject is new technologies and new human rights, and I would like to start with the question, what is new in new technologies? So a tool is replacing an inventor, becoming even more creative than human being. And AI learned to win chess by making moves human grandmasters never considered. And AI discovered a new antibiotic by analyzing molecular properties human scientists did not understand. And AI is transforming how humans are experiencing reality. This synthesis is brought to us by three distinguished authors of a book, The Age of AI and Our Human Future. I think Mr. Kissinger, Mr. Schmidt, Professor Kissinger, Mr. Schmidt, Professor Hattenlocher. I'm not going to discuss their credentials. However, I share their view. A tool invented by humans is able to gain control over them. It is crucial. But what is human in human being? Creativity. Creativity, the God spark, makes human superior over their tools. But now the tools are equal, almost equal, and maybe superior over human beings. You have here this magnificent moment in which God is creating human being, but in what form? Just giving to the human being a possibility to be creator. The God is creator, but also the human being is creator, thanks to this special appointment, special meeting of two minds. This is just a human brain here, painted by Michelangelo. And according to European Parliament report of 2017, ultimately, there is a possibility that in the long term, AI could surpass human intellectual capacity. It was several years ago, but it is really a long term. AI is already creating reality, mostly political reality. For example, this is just what happened with President Trump. Of course, it is deep fake. It's not true, but we have an example of post-true, an example of creation of reality. AI have some problems. You see, Mr. Trump has almost 4 legs, also here, too much legs. But after some time, it will be more perfect. And AI is also creating graphics, art. I asked AI to be useful and to create some illustration for my presentation. And I asked to illustrate the opera Carmen. What AI gave me? Excellent. It is just what I would like to have as an example of Carmen. My imagination is in, I would say, strict coexistence with the imagination of algorithms. I expected that because it's 19th century Spain, that Carmen should look like the lady here. And a chess. I asked AI to illustrate the chess, and it is interesting. It brought me an eye, I would say, imagination symbol playing chess with an eye, not with human being. I asked AI to illustrate the notion of freedom of thought, and AI gave me this interesting image with the open cage. Of course, it's freedom and maybe gender balance, if I would expect gender balance. Anyway, there are voices of warning. And this is a very famous warning from Stanisław Lem, an author of a very interesting contribution to the literature focused on technology. And Lem noticed that we are all in the technology trap. It means that the catastrophe is inevitable because we are not able to govern those terrible instruments which were being invented. And I asked my AI to illustrate the notion technology trap. And what I have received is something terrible, something very sad, something very confusing, and something very similar to reality. There is a lot of people with all those screens, and at the end, this terrible creature, which may symbolize the technology dominating over our world. Other voices of warning. Nick Bostrom. I'm not going to introduce him. He is sufficiently famous. And his view is that for a child with an undetonated bomb in his hands, the child, we are the child. A sensible thing to do would be to put it down gently, quickly back out of the room and contact the nearest adult. Maybe he is the nearest adult, but it is impossible. Some little idiot is bound to press the ignite button just to see what happens. So another warning. And Shoshana Zuboff, her view is very interesting because according to her, we are experiencing a new reality, a new form of capitalism, surveillance capitalism, a new economic order that claims human experience as free raw material for hidden commercial practices of extraction, prediction, and sales. The origin of a new instrumentarian power that asserts dominance over society and presents startling challenges to market democracy, according to me, to democracy as such. And Elon Musk, with his open letter, we call on AI labs to immediately pause for at least 6 months. If such a pause cannot be enacted quickly, governments should step in and institute a moratorium. Impossible, because governments are involved in the process of development of AI for the military purposes, for the surveillance purposes, for the control, the super control over society. And very interesting recent view, May 2nd, Geoffrey Hinton. He is a great creator of an eye. And in the interview, he expressed an opinion that AI is an existential threat to mankind, existential threat. So what can be done when AI is being increasingly put to practical uses and the prospects arises of humans becoming more and more AI dependent? I suggest that new rights could be enacted. The right to be governed by humans, habeas potestatum humanum, and the right to one's thoughts being free from technological mind-bending interference, habeas mentem. This necessitates that a constitutional and international dimension be imparted to a right that stipulates that the key state-level decisions impacting human condition, life, and freedom must be made by humans, not automated systems or other AI conceptions. And if artificial intelligence were to make decisions, then it should be properly equipped with value-based criteria. And the principle habeas potestatum humanum is of crucial importance of the survival of democracy in contemporary world, because the importance of the right to be represented, governed, and judged in court by humans is highlighted by the prospect of threats that may arise if control of society is taken over by the tools intended to serve its security. And then, while it seems fair to acknowledge that a democracy may sometimes allow for indispensable restrictions on human rights, with minority rights respected, of course, it must be emphatically demanded that such restrictions may only be imposed by humans exercising legislative, executive, or judicial powers, not by algorithms, computer software, and applicable AI forms. I asked my AI to create some graphics, and the response was for the habeas potestatem humanum, and the response was, it doesn't look very nice, potestatem humanum, hierarchy, and something terrible from the top to the bottom, and a lot of people crowded and looking for above. And another graphic, which is a dark room crowded of people, and something in the center of the table, maybe Bilderberg meeting, because it's rather without the access of other people. Anyway, it doesn't look sympathetic, very sympathetic, this illustration. And crucial right to privacy, the very survival of democratic system, with its roots in the dignity of the person, requires that the right to privacy and protection of personal data be guaranteed. In practice, though, the right to privacy is among the rights most threatened and most illusory. Privacy is valued neither by citizens nor the public authorities. Incessant use of electronic communication being a must in public and social life, the abandonment of privacy stimulated by fashions that make new technology solutions highly coveted and sought after becomes a characteristic feature of emerging new culture. The culture of abdication of privacy protection may breed consent to the creation and practical use of technologies capable to penetrate an individual consciousness without his or her consent. It is the so-called mind reading. I don't like to focus on the notion of mind reading because probably it's too early, but I'm afraid that we are going to that direction step by step. There is a professor Hart in Texas who asked volunteers to be mind readed with the use of GPT chat. Well, maybe the Carmen completely according to my expectation is some kind of the reading of my mind, but it is of course a joke and nothing serious. So habeas mentem, the right to personal inviolability, understood as prohibition on its arbitrary breach by government and reflected in the centuries-old principle of habeas corpus, needs to be reinterpreted. Given the potential threat of interference in a person's mind without that person's consent, it is imperative that constitutions and international law proclaim the principle of habeas mentem. The principle habeas mentem, according to which everyone's right to intellectual identity and integrity, the right to one's thoughts being free from technological mind-bending interference, is as essential for the survival of the democratic system as the right to be governed by humans, and it may well prove equally endangered. And again, what my AI brought me on suggested subject habeas mentem. well, it is not very encouraging, rather destructive. This is interesting as a warning. To have a mental, to have your own mind, you need to have a helmet. To have a helmet which will protect your mind inside your brain. If not, your mind will be explored, for example, from the satellite. But this is, of course, science fiction. But 20 years ago, the idea that I will illustrate my presentation using algorithms would be also a kind of science fiction. And the principle habeas mentem is crucial for the human dignity, because this principle, reflecting the need to provide guarantees for human internal freedom, may prove to be the last redoubt of human dignity, threatened as it is by loss of the rights to privacy and to informational identity. And now, conclusion. Of course, I'm not able to give a conclusion. I have no idea what future will be. Que sera, sera, what will be. But in contemporary world, the prospects for human rights are as limited and discouraging as always were. What we could do to have a common view on human rights in the present world? There is absolutely no common spirit. Everyone is lost in his own interest and tendencies. So I asked my AI to illustrate the subject Conference on the New Human Rights. And the result is interesting because it is not so encouraging. We have here the dark man who has everything in his hands. The only pole word. This is the point of, I would say, decisive decisions, 1 point. And then there are different people. Some of them looked like being hanged on this idea of human rights. And probably this form of answer to my question is interesting. Writing a book on the new human rights, I would use this graphic. And it is, I would say, intriguing rather. So let me thank you for your attention. And this is, of course, Leonardo da Vinci, not a form of artificial creation. And let's hope that human being as creators will not be replaced by algorithms. Let's hope. And please forgive me because I'm involved in the current judicial reform in Poland, and I should leave you to join as an expert a meeting of a parliamentary committee of our parliament, which is working on the subject of judicial reform. So it was a pleasure. I'm very sorry not to be able to contribute to the discussion. And I hope that maybe if something will be published, I could contribute to the future volume. Thank you again for your attention.
Thank you very, very much, Professor Potocki, for this extremely interesting and very inspiring speech. I assume we don't have time for any question. So yeah, so for me it would be very interesting whether we could apply this AI somewhat to education, because for me dignity, human dignity, so the purpose of human rights goes always with education. So that would be my perspective. Thank you so much once again for your time, for your dedication, and yeah, I can understand very well that you are very busy. So
thank you. Thank you. Please forgive me.
Yes. So our next speaker will be Professor Izabela Gawłowicz, my dear friend from the University of Zielona Góra in Poland. For your information, Zielona Góra lies on the German border, so it's almost an international university. We used to work together at this university for several years, and I am very happy that Iza accepted my invitation today. Professor Gawłowicz is a specialist of international law, of public international law. She is passionate about International Court of Justice and the importance of the court to the development of public international law. She is also the president of the trade unions at the University of Zielona Góra. So she is very committed to employee rights and the ways in which trade unions influence the legal culture in workplaces. Today, she will touch a very important topic that goes together with the war that we currently experience in Europe. So her topic is the response of international law to the use of assault weapons, a communication approach. Isa, please, the floor is yours.
Thank you very much. Do you hear me? Can you hear me? Thank you. First of all, I would like to thank you, Anna, for inviting me. I would like also to thank Professor Era for having me here. I'm thrilled to participate in such an interesting colloquium. I must say that I'm honored to be next person by Professor Piotrowski. However, I'm afraid I cannot offer such fascinating content to the distinguished audience, because as Joanna said, I will speak about the response of public international law to the use of assault weapons in the context of communication. I just ask, can you see my presentation? Great, thank you. So first, I will explain why I connect assault and communication. Then I will describe a little bit assault as a measure, anti-satellite measure. Then I will follow with some difficulties with lawmaking, with codification in public international law, where space law is no exception. Then I will present space law existing regime and its needs, and assault existing regime. And then I'll try to make some conclusions. So why to connect assault and communication? The rationale behind the theme of my presentation is multifaceted. Centuries-old established norms of public international law are based on values universal to all nations and civilizations. And I am deeply convinced that in the world where some states possesses a variety of instruments to pressure or even coerce, including militarily, other states only universally accepted standards of conduct under the inclusive umbrella of communications ability can offer an effective mechanism to build and to maintain a modern international order that could ensure the world security. Respect for the rules of international law by all the world's states, or at least most of them, is a dependable element that can assure building a supranational yet not non-institutional community. Common values protected by international law should have priority and play a stabilizing role for the lawmaking activity of subjects. And of course, from decades, from centuries, states and humanity in general look for the way to ensure those universally accepted standards of conduct, to regulate them. The best and most traditional, profoundly tested way to shape international legal order, in general, as in outer space particularly, would be always by making universal treaties binding most of the subjects, most of the states of international society. The most important, complex, and most universal treaties have been adopted in the second part of 20th century. And there are some difficulties with the treaty-making activity in the last few decades. What can be easily noted if you follow at least some of works of International Law Commission as to the few important questions of public international law that have not been codified so far. For instance, jurisdictional immunity of states, responsibility of states for internationally wrongful acts. We have draft, but we don't have convention in this area. Diplomatic protection, subjectivity of international law, at least open catalog of subjects, the catalog of Jus-Cogens norms, and a few others. Before I will return to this topic, I would like to say a few words about ASAT, anti-satellite measures. I purposely use the term measures, not the term weapon, although most of people, most of experts even, use the term weapon according to ASAT. I would stick with this term measure to show that ASAT can be innocent and can be danger. It depends probably on the intention of the state. The SOL technology appears in 60s, so of course it's not something very new like artificial intelligence, but this technology is developing very fast and can be used for many different purposes. It can be used to remove satellite. It can be used to defend satellite. It can be used also to blind satellite. But it is designed to incapacitate and it is able to destroy satellite for strategic or tactical reasons. ASAT can be described as one of the most important achievements of technology used in outer space. The states that use ASAT consistently claim to do it only for peaceful reasons. And if you are interested, you can see that there is an ongoing debate among states how to describe ASAT, what terms to use, is it weapon or is it just a measure? ASAT has not been tested in warfare, but a few countries successfully shot down their own satellites to demonstrate the abilities of ASAT and, of course, to demonstrate their power, such states like Russia and China. So potentially innocent defensive measure like ASAT can be used in much more dangerous ways. Why then international treaties do not prohibit some kinds of ASAT's use? Well, there is no such treaty, and probably there is no possibility to make one in near future. That's why I mentioned before some difficulties with lawmaking in public international law in international area. I would like you to have a look on the straight core of existing regime of space law. We have five important treaties, and purposely I bolded the dates of adopting those treaties. So we have Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. So this is 1967. We have so-called Rescue Agreement, 1968. We have so-called Liability Convention, 1972. We have Convention on Registration of Objects Launched into Outer Space, 1975, and we have agreements governing the activities of states on the Moon and other celestial bodies, which is the youngest one, 1984. And then we also have a treaty banning nuclear weapon tests in the atmosphere, outer space, and underwater, which is 1963, and Treaty on the Non-Proliferation of Nuclear Weapons, 1968. So we can see that this regime, in fact, this legal regime has been created in the second part of 20th century. Is something wrong with that? Of course not. However, this whole regime has been created in the times when some things, some instruments hasn't existed. So, and no one could predict how to behave in outer space, in outer space when those new instruments will appear. So we have no ASAT, no anti-ASAT or ASAT banning treaty. We also don't have new outer space disarmament treaty. What do we have then? We have a few United Nations resolutions calling for a halt to one type of ASAT testing in outer space. All those resolutions have been adopted in November, December 2022, last year. So by those texts, United Nations promote norms of responsible behavior for outer space activities. Such a commitment would be an urgent initial measure and aimed at preventing damage to the outer space environment, while also contributing to the development of further measures for the prevention of an arms race in outer space. Here, I would like to return for a moment to difficulties with lawmaking, with codification in an international area where space law is no exception, because then I would like to highlight some advantages that has so-called soft law. According to this development of new technologies. So there are some voices in the doctrine proclaiming a crisis in international law and its development and those are voices about complaining about insufficient, from the perspective of the international community's interest, lawmaking processes. This insufficiency can be caused by a high number of existing states, by the new role of other than states entities in the international community endowed with treaty rights, by limited ability to form transregional associations that could represent and adopt a common statement, by the dynamic of civilization changes, of course, and the rapidity of technological development that also should be mentioned. So in this situation, while we are facing all those difficulties with lawmaking, all those difficulties with codification, maybe it's time to adopt a new and less conservative approach to international lawmaking. And it might lead to accept soft law as the additional source of international law. It might lead even to acceptance of judicial activism in international courts. This second thing was my professional interest for many years. I will not speak about it now, but from those years, I took from my research in those years, I am convinced that we need a new approach to public international law. We need more flexibility, we need more sensibility, and we need less formality in public international law. The thing I'm talking about, it's not quite new, because in the doctrine, it's already 14 years ago when David A. Koplow directly expressed his concern for the stability and security in outer space, as well as for the commercial and military reliance on satellite technology. In Koplow's opinion, it's customary law that gives answer for the technological and legal challenges in outer space. I don't dare to disagree with Koplow. However, I don't support the vision of leaving the state's behavior in quite new, non-entirely explorated area with all its resources and all those competing priorities of the states and their rapidly developing technological abilities to centuries-old principles that indeed have been tested in very different circumstances, but they are not detailed enough. And that have been created in the times when no one could even predict the appearance of such measures like ASAT. There are some significant advantages of soft law. Maybe soft law is the answer. I think this is the answer for such challenges like the regulation of measures like ASAT. Among those advantages, we have that it's easier to achieve them than other more traditional forms of law. They are quickly developed. They facilitate compromise among different subjects of law. They facilitate global cooperation. They are well suited to developing ethical standards, supporting coordinated action where hard law is lacking. They are well suited to promote universal values. They do not diminish a state's sovereignty, so it's likely to be better received. Most of all, soft law is better to promote communication among nations. States don't like to be under the pressure. They rarely accept new obligations. The exception of it can be measures for dispute settlement, peaceful dispute settlement. It's really a rare situation when the states that have the dispute go to the court. They prefer to make mediation, conciliation, negotiations, because they don't want to lose control. They don't want to risk anything. So maybe it's time to change this formal, this tough approach according to law, and maybe it's time to estimate it soft law finally. In the absence of new outer space disarmament treaty, the world can definitely, in my opinion, turn to soft law as viable alternative pathway toward enhancing space security. So those are my goals. My goals of my presentation here is to present the UN resolutions that regulate ASAT measures as recognized, important, and dynamic instrument of communicating universal values protected by international law, and to convince the distinguished audience how those underestimated legal instruments, while not being formally binding, may impede the erstwhile freedom of sovereign states to proceed untrammeled toward the weaponization of space through the testing and use of potentially innocent assets. The democratic mandate given by the states to UN to form international law by resolutions enables avoiding the most difficulties connected with the traditional way of lawmaking, treaty making. I also think that it could be the chance for United Nations to reconnect with international society, to rebuild its authority. The authority of law cannot be divorced from lived reality, the civilization's development, as well as from the demands of justice. Law not only protects values, it communicates values as well. Law is inseparably connected with its communicative role, and each document, each legal act not only communicates the law, which is prohibition of certain behavior or order of certain action, but also communicates values protected by law. The more values are communicated by law, the stronger this law is. So paradoxically, ASAT revealed the new and improved face of public international law. Instead of conclusions, I would like to recall the words of very famous Polish constitutionalist, Professor Ewa Łętowska, whose book I wrote lately. I had honor to read lately. The law is not the text, it's the mechanism. The law is not for itself, it serves to people and to society. The law is supposed to be made to optimize social relations. If the law stops to fulfill its crucial role, it's time to change it. Thank you very much for your attention.
Thank you very much. Thank you very much for this very interesting perspective. Now I would like to give the floor to Professor Anna Borowska, my dear friend from the Faculty of Applied Linguistics. So as you can see, I am a very lucky person because I have so many friends that I could fulfill the panel with, with them. Yes, Professor Borowska is a very special person. So I think she's very unique. She's English language proficiency expert for aeronautical communication. She is also head of aviation communication research center at the University of Warsaw. A few years ago, she was given a position of a seconded national expert at the European Commission in Luxembourg, where she mainly worked on civil aviation terminology projects and legal text translations. Currently, she cooperates with authorities in Belgium and France on aviation English testing. Please, Anya, the floor is yours.
Thank you very much for this marvelous presentation, introduction of me. So today I'm going to tell you a little bit about pilots and how they communicate. Just fighting for a moment with the with this, of course, with this presentation and Zoom presentation. Could you please give me any sign that you can see my presentation in presentation mode, or is it just the working one?
It's a presentation mode. It's okay.
So you can see the slide, yes? The first
I can
slide.
see the slide.
Okay, because here it's good. You can see the slide heading to safety, right?
I can see background purpose.
Okay, okay, good. Thank you. So it's another one. Okay. Good. Now should be the title one. Okay,
Yes,
so we take off now. We are taking off. Because I want you to look at the title. Actually, it's more about law than technologies, but still technologies are somehow involved in my topic. Because if you think about flying, if you think about aviation, all of us, now we fly, yes, we transfer our bodies from one place to another. And I hope from now on you will think a little bit about this fact. How do the pilots, how do they communicate? What's going on with this communication? How does it work? And so on. So actually, it is not as we think that they just know the language, they just speak English, that is aviation, of course, aeronautical English and aviation language used globally. So this is not just like we can imagine that they use the natural language that we all share. Actually, here there is also sort of technological touch in it. That's why I decided to shed some light today, including some legal challenges for communication testing, because the other thing is that they speak the language, but somehow they must be tested. It is the standardized global requirement that each pilot flying in the airspace for commercial or touristic reason that requires using English, they must have the entry in the license. Okay, so we enter the word that everything in aviation actually standardized, everything is normalized. There is nothing you can do without the reference to some documents and so on. So the language is prescribed, the communication is prescribed, all the texts that are written, they are prescribed as well. Training methods, testing, rating, everything is really prescribed. So we cannot escape legal procedures, we cannot escape legal life if we want to fly. I mean, of course, not only airline pilots, not only military pilots, but also those in small planes and helicopters. So what we need to know is the specialized context, aviation regulations, and another sort of technological touch that we can talk here about, that one that I mentioned, is the specialized tool, sub-register, I would say, sub-language that they use. And everything is just to enhance the global safety. So this is what we mean. So it was long time ago, 1951, when English has become the language of aviation. Still, it is recommended to be used in global aeronautical routine and non-routine situations. By routine, I mean the simple situations like starting up, taxiing, taking off, and so on. By non-routine situations, these are all incidents and emergency elements that appear. Unfortunately, every day something happens. Every day there are some incidents. Also, communication is a contributing factor. Many reasons. I have no time today to tell you, to talk about the reasons, maybe next time. But why this English is so important? Of course, it is to simplify the rules of the air, to make the life of pilots and air traffic controllers easier all around the world. But these are not only pilots and controllers who communicate, these are also pilots and pilots, because sometimes they help each other when airborne, when in the sky. Controllers and ground services, pilot and ground services, and all of those communications are expressed in a prescribed language. So the language that is not natural. This is a sort of the code. This is still, it's maybe sometimes it's hard to call it a language because it is actually more like a code, like a tool. You cannot be really creative when you use it. And now we can imagine that probably you heard some examples like Mayday, Roger, Wilco, and so on. So these are the elements of the coded tool they are using. So this is on the one hand. So this technology already entered the communication in the form of the code that each pilot has to master. But this is not everything. They also should know natural language. And this illustration maybe will help you to understand what exactly we test. I am the examiner of one of the testing system in France, Belgium, and Poland. It is under EASA regulations, but approved by ICAO, by International Civil Aviation Organization. And just to show you how it is organized, you can just have a look at this circle here. When the core is the standard phraseology, so this is the code. This is the official name of the code. If you are more interested and you want to look for that, you should Google the standard phraseology. This is the aviation code. And actually, all the pilots, they must be tested if they know the code. This is the first step. The next step is the plain aeronautical English. So this is the code plus natural elements of the language, useful in some emergency non-routine situations. But again, this includes standard phraseology elements. And again, it must be tested. They must be those elements, this language. Here we can say it's more like a language. They, again, must be tested. So again, we need other instruments, other tools to test it. And then, of course, we can add some general English. We can add some other elements of language in use, understandable to all of the community. Okay, coming to be more precise, when we talk about this pilot's communication testing, and we should remember about two main documents. Of course, there are some more, but these are just like mother documents for the testing. So the first one is Manual on the Implementation of ICAO Language Proficiency Requirements. And here, if you would like to look for the details, legal requirements, this is chapter 6. And this document is prepared. It is actually followed by all the ICAO member states. So all around the world. This is the global one. The other one, the light blue one, this is of course EASA, so European Aviation Safety Agency. So this is the one that operates in Europe. But here actually the EASA, of course, they introduce their regulations, and they are based on ICAO regulations. So we cannot escape them. This is high-stake environment. Pilots talking to the controllers, they are high in the sky. If they don't know the common language, they don't share the language, there are incidents and there may be some problems, of course. So this is this high-stake, very risky environment. And you can just have a look at quotations from some points from the document, the document, ICAO document 9835. What should we test? All the qualities like fairness, validity, reliability, practicality. But the other problem is still for us, for test designers, for examiners, how to measure the speech sample given by pilots, because we can imagine that there is a test, the pilot is coming to the test, but still how to measure the sample. And this is what ICAO actually standardized as well. So there is so-called ICAO rating scale and the language requirements, and each assessor, each examiner has sort of the checklist, and that the one that we must follow when we assess the pilot. I will skip for a moment, just I want to show you an example of the test I'm working with, so you can have the picture, you can be more in the picture how it works. The test is called FCL 055, so this is actually the subchapter in the CIASA document, but they originators, designers of the test, they left us the same name, and this is CIASA and ICAO approved the test. So two parts. This test comprises two parts. So the part number one, it's sort of evaluation of general English ability. And it is based on short introduction. It is sort of warm up that we talk with the pilot about the professional background and flying experience as well. But this is recorded as well, and all the language mistakes, all the communication, miscommunication elements, they are all written down in the report. And then they are reflected in the general assessment. So this is very important for them, because if they are weak, if they gather a lot of bad points, I would say, they cannot have their license, they cannot fly, they cannot earn money, they cannot support their family. So it's really, it's not like it looks like that it is a piece of cake. Then they are given the photograph with some aviation-related picture, like these are mainly emergencies, so some sort of incident, something happens in the cabin, something happens in the cockpit as well, and or outside at the airport, and they have to present it in a way they described it to the person who doesn't see it. Then they read the text, they paraphrase the text, and there are some open questions as well. So this is the part that is done by the linguistic assessor. And the other part, number two, this is an evaluation of operational ability based on radio telephony communication during a simulated flight. So this is the part that is assessed by operational assessor, so the pilot or air traffic controller. So now in a nutshell, you can see very quickly, you can see how the test looks like. And now I would like to come back to the most important thing in my presentation, because you needed some background knowledge for that. The challenges for this testing. So actually, what it means that, that there are some challenges. Okay, I guess legal challenges. So you can imagine that there are some tests, more or less, they are, it's not like each country has a test. No, there are not so many tests, aviation English tests, because they are not easy to create, they are not easy to make. First of all, there are those ICAO EASA requirements. So the given country has to follow the recommendations. These are more recommendations than obligations when it comes to creating the test design, the test, and to design the test. However, there are some drawbacks. First of all, this is like uniformity. like you can see in the first bullet point, the uniformity of the ICAO requirements. Sometimes in one country, they are different than in the other, and these are still the countries that decide. It cannot be like the ICAO decides for everyone. No, they present some recommendations. And of course, there are some legal requirements for pilots and for test designers, but still, it's not like that you cannot do this, you cannot do another thing. Generally, those who verify the tests, there are also people, so this human factor is involved. And there is a clear lack of equivalence between the ICAO levels issued by different tests and states. So maybe the levels are not the same. The levels tested by different tests, they are not actually compatible. They are not the same. And this is the biggest problem nowadays, how to check, how to verify that they are actually, they check the same, how to verify the test samples from Kenya, from Japan, and from Poland, for example. Of course, ICAO tries to monitor everything, but it is not so easy. It's not so easy because they have their representatives in each country, and then each country has their own intercultural issues that they follow. So it's not really so easy. That's why we can talk about another kind of challenge, variations in what language skills and language knowledge those ICAO tests assess, to the extent to which this relate to the language communication context and proficiency levels needed for safe aeronautical communication. So another problem here. So definitely we need more effective tasks, we need more effective tests. Some of them are really good, and they are assessed by many bodies, many authorized bodies, like the one I have just presented. This is authorized by EASA and ICAO as well. So a lot of people work on it. But in other countries, sometimes it is not so strict. The policy is not so strict, unfortunately. What we should remember about is also that the emergence and spread of less effective testing practices, which may not assess the full range of necessary language skills and award ICAO levels at a lower standard. This is what I already mentioned. Sometimes one level is not compatible with another in another country, and this is not fair. Of course, this is not fair, but actually this is a challenge, how to improve the situation, how to make it better. Because on the whole, we can say, okay, it's quite easy. Just take some representatives, ICAO representatives, send them to the given country and they can verify it. Yes, but in reality, it's not possible. It's not possible because it involves a lot of money invested. It involves a lot of training. So this is done faster, and those people who feel responsibility for the safety in aviation, they design better tests, of course, and they design tests that they should be like the real ones. But the rest, it is really a human factor still involved in this context. So if you ask actually who should design such texts, I can say that, of course, trained linguists, but also not only linguists, with pilots, with operational personnel, with lawyers included. So it looks like this should be a really big team with multi-purpose representatives from all of those contexts. So challenges still exist. I hope I didn't I didn't frighten you to fly, because don't worry, all the pilots are tested, and the tests still, the tests work in a sort of good way, because we don't have accidents. We don't have very big accidents right now. So some delays and some incidents in generally, but so it looks like this works. But if I come back to the question from the introduction, can we substitute pilot communications, aeronautical communications? Can we substitute them with technologies? at this moment, unfortunately, I must say no, because it's they can be supportive, but a lot of research is done, and it's not now it's not really possible. Thank you very much. I think my time is over. Thank you very much.
Thank you, Anya, for this really unique perspective from this very inspiring, very international presentation. And yes, you already heard very different approaches to the challenges, to the technological challenges from the international legal perspective. And I would like to surprise you a bit now, because I would like to say that all the perspectives are gathered within one project. So we work together. We are, of course, we are colleagues, we are friends, but we also work together over one specific project. And also Gaston Becerra and our today's keynote, Professor Maria Cristina Paganoni, are also at part to this team. Let me share now my presentation. Oh. Just a second. Can you see my presentation? Okay.
Yes.
Thank you. Very good. Okay. So I would like to share the perspective of international legal communication. As I told you, it's a interdisciplinary approach from linguistics and from legal sciences. And I would like to explain how it is that we work together and that we can contribute actually to a common view. I can't share, oh, okay. No, I'm okay. So a few words about this International Legal Communication Study Program, how it is based in the University of Warsaw. So first of all, I would like to say, yes, a few words about Warsaw. So Warsaw is a capital city of Poland. Of course, it's much smaller than Buenos Aires, but quite big as for Europe. 2.5 million inhabitants, many tourists, lots of cinemas, theaters, music venues, museums. So in this regard, it is similar with Buenos Aires. We have 15 public higher education institutions, 240,000 students per year. So it is, of course, it is much less than in Buenos Aires, but it is more than in Berlin and in Prague. And it is quite a good city to study for students because it's relatively affordable in the financial sense. I don't know if I will be able to start this. Probably not. Okay, I am not able. I wanted to show you a small movie, but it's impossible in this mode. So I will continue without. So the University of Warsaw is the largest Polish university and also one of the largest European universities in terms of the number of students. It's actually similar to the University of Milan. So we have 7,500 employees, more than 40,000 students, and amongst them also lots of international students. So I know it's not impressive from the perspective of Buenos Aires, but it's really a lot in the European terms. The University of Warsaw has 42 faculties, actually already 52, because the Faculty of Medicine was created last year. And the project of which I am talking now, it's based in the Faculty of Applied Linguistics. So this is this faculty. And we even have also people involved from the Faculty of Law and Administration, like Professor Piotrowski, but also from the Faculty of of journalists, information and book studies. So these are sociologists. So we have also this perspective. At the University of Warsaw, we have altogether over 100 programs in humanities, social sciences, natural sciences, and amongst them we have also 28 English language programs, and one of the programs is exactly this International Legal Communication Master Program. So yes, here you can see all the English language programs with international legal communication, so second cycle studies here in the second row. Of course, it is maybe a little bit easier for us to cooperate internationally, as it is the case of the universities in South America, because we have, the European Union makes it a bit easier. We have this Erasmus program which enables us to make academic exchange, of course, in regard of students, but also with regard to academic teachers. We also have other programs like Deutsche Akademische Austauschdienst or yes, many others, but the Erasmus Plus is the most efficient one. The University of Warsaw is involved in 5 important networks, and I would like to highlight the first one, which is the 4U Plus Alliance, which also will give you some additional perspective of how we operate. So the 4U Plus Alliance is it's an alliance of universities. It is based according to a European Union program for the so-called European universities. So we started being 6 universities: Charles University, University of Heidelberg in Germany, Charles University is in Prague, University of Heidelberg is in Germany, Sorbonne University in Paris, University of Copenhagen in Denmark, University of Milan with Maria Cristina Paganoni here, and the University of Warsaw, and last year also the University of Geneva in Switzerland joined the 4U Plus Alliance. What is it actually for? So we got a grant from the European Union. It was 4 years ago. Now we are in the second grant, second financial program, and the aim is to establish a coherent institution with yes, sovereign rights of every of the universities, but we will strive with time for the so-called common degree label, which means that we provide common studies. Yes, you can see here all the universities, and the University Paris-Assas is becoming, it's actually about to become associated partner, and with time it will probably join the alliance on a normal conditions, on a rolling basis. So altogether we have for the moment more than 300,000 students, which would be comparable to the University of Buenos Aires. How does the 4U Plus work? So the 4U Plus works in the so-called flagships, which are thematic areas for interdisciplinary, innovative education, research-based education. And we would be, with our international legal communication, we would be based in the second flagship, which is called Europeanness, Multilingualism, Pluralities, and Citizenship. And how it is that we actually have this unique, it's very unique study program. We have at the University of Warsaw a program that is called Excellence Initiative, Research University. Being the best university in Poland, we got special fundings from the state, and we were able to introduce new study programs. And this international legal communication is one of them. I am very proud that it was my original idea on which I have been working for several years, and yeah, and this concept has got the fundings from the university. So now this is actually our leaflet. I would like to show you this and explain a bit about the studies. So this is a research master study program, which means that the students are expected or are allowed to conduct their own research. The studies are conducted in English. It's a master, so it means that this is a second cycle studies. It lasts 2 years, and so the main question for students who want to apply is whether they would like to create, interpret, and explain the law in an understandable language. You can see here, this is the main entrance to our university, to the old part, and this is how our building looks like. So we make such a collage, and yes, this is our building where we teach in this program. The program is designed in the following way. So in the first year, the students are taught methodologies. They learn about methodologies in the law, in the legal sciences, but also in applied linguistics. We have, for instance, experiment as a methodology of conducting research, case studies, statistics, big data and data mining, including text mining, that was taught this year by Gaston and also by Maria Cristina together. We have also pure methodologies in law and pure methodologies in applied linguistics. In the second semester, students are taught a module that we call competencies of a researcher. And in this module, students learn to obtain grants, to apply for grants, of course, to disseminate their public results. They are also taught how to keep the intellectual property rights. So this is the second semester. And in the third and fourth, so in the second year of studies, the students can choose upon 3 specializations. You can see the specializations here, and here you can see also the main courses within the specializations. So first is the design thinking in law, and that would refer a lot to the presentation of Professor Izabela Gawłowicz, because yes, it's about terminology, it's about conceptualization of law, also in the terminological sense. So it's about making law in a linguistically good manner, so it is understandable, so it can be applied without problems. So you can see here in the courses law and genre, legal syntax and semantics, interpretation and justification in jurisprudence, conceptualization of law, but also logic and cognition of law. And the second specialization is named transference of legal knowledge, and it is about providing legal information either to communities of practice or to the public, just to everyone. So making law comprehensible to people. And here in this specialization, you can see clear and plain language in law, linguistics and legal ethnography and anthropology, sign linguistics and visualization of law, and this course would refer to the application also of AI, so we also plan this here. And also legal discourse in and through media, that is going to be taught by Professor Maria Cristina Paganoni from the University of Milan. The third specialization is epistemology of lawyering. That refers to the proper construction of a case that should be brought to the court, narratives in court, how to make arguments, pragmatics of legal language, argumentative legal discourse, and also negotiations and mediations. So this program is actually completely unique in Europe. We don't have another such program. The first specialization, this epistemology of lawyering, it corresponds in a way with the American approach to legal studies, with this American pragmatism, but the first and the second are completely new. So the students, after accomplishing the studies, they can work in international organizations. They can, of course, work at the university doing their own research. They are welcome at the PhD program, but they can also be just involved in linguistic activities, such as conducting a translation project, or being a proofreader or post-editor, of course, on a high level of specialization. And yes, who may actually apply? For whom is the study program, whom is dedicated? So actually the first and the third specialization is more dedicated to lawyers, but the second is actually to everyone, for everyone. So everyone can apply, everyone can take part, and everyone can be a researcher in this area. We follow a two-step recruitment process, which means that the students are supposed to submit a motivational letter in English, so they should prove in a way that they are able to conduct research in this area. And then we have interview. So in the interview, we check whether the students are really able to communicate, to express their ideas, whether they are able to study in English. Thank you very much for listening to me, to this short presentation. I know that Anya regrettably needed to leave our meeting, so yeah, we actually were not able to have an internal discussion anymore. But if you have any questions that Isa and me could answer, we are on your disposal. Thank you very much.
Well, thank you, Joanna. Of course, thanks also to the other presenters. We have the option for chat, which is enabled for if someone wants to leave a comment or a question. And I forgot to say something important on the beginning, is that we will be sending the certificates of attendees tomorrow or the day after. And also, I'm leaving you our email in case you have any inquiries or consults. That I'm going to put this on the chat, and I'm going to show then a presentation with the email. Is sociología@uflo-universidad-edu.ar. En castellano me estaba diciendo que tenemos la opción del chat habilitado, por si alguien quiere dejar algún comentario. Y que nuestra dirección de mail es sociología@uflo-universidad.edu.ar, y que vamos a estar mandando los certificados de participación entre mañana y pasado. No sé cómo estamos de tiempo, si no, tenemos 5 minutos libres como para recargar los mates. Gracias, Benjamín. Decía, tenemos 5 minutos libres antes de la presentación de Cristina, así que si quieren nos tomamos este pequeño recreo y ahora cuando volvemos vamos a la presentación de Cristina.
Gaston, thank you. I'm going to drink half a glass of water and then I'll back.
Okay, maybe we can take 5 minutes, all of us can take 5 minutes, and then we can go back for Christina's presentation.